Okay, so just to let everyone know, this meeting will be recorded. I want to say thank you all so much for joining us today. Today, we are having a session of our Financial First Friday hosted by the SAFE program. I'm your host, LaToya Hall. Just a little bit about SAFE. So SAFE is a program that's housed out of the Institute of Gerontology at Wayne State University. At SAFE, we are dedicated to assisting older adults with financial issues, whether they be consumer financial issues or financial issues resulting from scams or identity theft that older adults need assistance with in resolving the financial fallout from. That's a little bit about SAFE. We are available for one-on-one assistance and live programming for individuals who are looking to have speakers come out to talk to groups about scams and identity theft. And during the beginning, there was should have been a running PowerPoint with SAFE information on it. And again, my name is LaToya Hall. I am the SAFE Program Director. I can be reached at 313-664-2608. If anyone has any questions about SAFE program services or programming. And I also can be reached per email at l.hall@wayne.edu. Today we have attorney Howard Collens with us, and he's going to be talking about estate planning. Mr. Collins, attorney Collins, is a elder law attorney, and he does a lot. He's a friend of the ILG. He does a lot with estate planning and helping older adults to prepare estate plans and understand just what that entails. And so he's going to be giving us a lot of useful information today on estate planning. Howard, would you like to introduce yourself?
Sure, LaToya, thanks so much for having me this afternoon. Thanks for everyone for showing up. And I hope this will be a useful hour for everyone. My name is Howard Collins. I'm an attorney at my law firm is called Galloway & Collins. We're physically located in Huntington Woods. We're right on Woodward at Lincoln, just north of the zoo. We have a firm that focuses on doing estate planning, estate administration, elder law, and real estate work. And I've been an attorney for, well, at this point, over 25 years.
Great. So we're going to get into it. The way this is, Howard, we are doing an interview format. So I will be moving forward with some very general estate planning questions for Howard. I'll ask them. He'll answer, give us an idea of, some of what goes on with estate planning. And then we will take audience questions at the end after we finish all of the standard questions that I've prepared for today. So I guess our first question for Howard is, what are some of the main questions that individuals should ask themselves when going into the estate planning process?
Sure. So an estate plan takes on a lot of different forms, and people have different needs through the course of their life. And the concern that many people have is death, because as we know, everyone on this call and everyone we know will eventually die. And so estate planning contemplates what happens when a person passes away. But also importantly, estate planning needs to consider what happens if a person grows incapacitated. The problems associated with an incapacity are substantial, especially if the incapacity is a quick onset incapacity, such as someone having a stroke. But it can also be very frustrating in situations where it's a more slow-moving incapacity, like a person who's developed dementia, for example. So the kinds of things that I think are really critical, first off, is getting motivated to consider doing estate planning, because it's not usually people's favorite subject. I mean, it's one of my favorite subjects, of course, but the reality is most of us don't love thinking about the idea of growing incapacitated or dying. And so there is, I think, for many people, a hurdle to clear about just the idea of setting down and doing it. Many people, I'm told by clients, say, one of the barriers for them is just the belief that by engaging in the process of estate planning, they will hasten their death or their incapacity. And I have to tell you, I haven't read statistics on this, but I don't think it's true. I think that there's nothing that makes that connection. On some level, I think having a properly planned estate could actually be beneficial in the sense that you can check it off of the mental checklist. You can, get some peace of mind and stop worrying about something that may, be an immediate or a far away need.
So just thinking about, what you touched on with incapacity or other needs, because so often we do think about estate plans, we think about death and dying, and we think about wills, but what are the essential pieces of a good estate plan? If you were putting together an estate plan, like what are the essential pieces that every good estate plan should have?
Sure. And of course, it will vary person to person, and a well-crafted estate plan contemplates an individual need, right? There is no one size fits all estate plan. Similarly, there is no such thing as a simple will. None of this is simple if it's done right. And it's not to say that it's absolutely impossible or hard. It's not. It just needs to be done well. So the most typical pieces of an estate plan, I think, are powers of attorney, and those are two main kinds: of financial power of attorney to allow a person to nominate an agent to handle financial affairs, and then a patient advocate designation, which is a medical power of attorney, and that would allow a person to appoint a patient advocate. Upon incapacity, that patient advocate would have the authority to make decisions about applying or withholding medication, medical procedures, end-of-life decisions. Connected with those, with the medical power of attorney, the patient advocate, is a Hipaa release. So a standalone Hipaa release, I think, is a critical document, especially if you're interested in your loved ones being able to learn about your medical condition. So if you have a hospitalization, but you haven't given any authority to anyone else to learn about your situation, the hospital is not likely to release that information unless they're somehow convinced otherwise. But and the HIPAA releases that we often see at our doctor's offices think about releasing information to other doctors or other hospitals or insurance companies, but many times they fail to recall that we have family or friends we want to share that information with. So having a HIPAA release is a critical piece of that as well. And then, thinking about other kinds of documents that go with those powers of attorney, having a will may be a sufficient focus for an estate plan. We can talk more in depth, obviously, about what a will does and how it functions. But having a last will and testament would be a central piece of a well-planned estate. And then perhaps having a trust, and trusts come in different formats, but the more common approach is a revocable trust, which, once it's set up, allows a person's assets to be managed. Excuse me. And even upon incapacity and at death. There are irrevocable trusts that could also be beneficial. It depends on the circumstance. Excuse me a second.
Mm-hmm.
I'm so sorry.
That's okay.
All right. I've choked myself up. Yeah, so those are the main components of a typical estate plan.
Mm-hmm. So you mentioned wills and trust at the end of that. What are the major differences? Because a lot of people, will use those words interchangeably, but they are two different documents. So what are the major differences between a will and a trust?
Sure, and I'll try and do this without stammering through.
That's okay. Take your time, Howard.
Yeah, of course, it doesn't usually happen this way, right? So if you think about a will sits around and waits until a person dies, and then it will control assets that are in the person who's died's name, if it's in their name only, without a joint owner, without a beneficiary. So if you think about, I don't know, a bank account, I mean, let's say that there's, I don't know, $50,000 in a bank account or an investment account that's just in one person's name only, and that person dies. If that person passes away without a will, there's a process that they'll go through for administration through the probate courts, and we can talk more about that too if you want. But if a person has a will, at the end of the probate administration, if that asset starts at the death in their name only, and they have a will, then that will describe who administers the estate. It will also describe the distribution of the estate. So that, on the most basic level, a will controls assets of a person who's died, whose assets are in their name only, without a joint donor, without a beneficiary. A trust is a different sort of approach. And I'm thinking about a revocable trust. It's effectively a contract. It's a document that gets set up by a person who is called the settlor or the grantor, and that's the individual who's making the document. And the trust creates this entity. It's almost like setting up a business. It's a third-party entity, so it's not you individually. It's a separate thing that provides a mechanism for holding assets while a person is alive, if the assets have been retitled into the name of the trust, and then provides for a mechanism for managing those assets through the trust if the person is alive but incapacitated for those assets that have been transferred in to the trust, and then provide a means for distribution of those assets after a person dies, assuming that the assets have been titled into the name of the trust either during that person's lifetime or after that person has passed away. The functioning of a trust is managed by the trustee of the trust. Typically, people will name themselves as the trustee over their own trust during their lifetime. They'll name a person who's the successor trustee. If they've grown incapacitated, that person would take over. And then let's say that they're with full capacity up until the day they die, the successor trustee would step in after their death and administer the estate. Now, one of the main benefits of having a revocable trust is probate avoidance both during lifetime and after death. The administration, generally speaking, with a trust doesn't require any probate court involvement. There are two circumstances where that is not the case, where probate court would get involved. One is if there were assets that the decedent left in their name only and not in the trust. And in those cases, that's a probate asset, and that will be caught up by a will. And there's a specialized kind of will that goes with a trust, actually. So there will be a probate involvement in that sort of situation. And then the other situation is where people are fighting about stuff. Even with a trust, a contested trust goes before a probate judge to be figured out.
Okay. I just want to mention as well, if you guys have questions, you may want to put them in the chat for right now, just so we can keep up with them and make sure we get all of the questions answered. Because some questions may come up as Howard is speaking to some of these things. And then the next question that we have is, so say a person, they decided to move forward with creating an estate plan. What type of information or documents should they gather or have on hand to create that plan?
Yeah, so in making an estate plan out, at the most basic level, you need to show that you're competent, right? That you have the ability to make the documents out as either your will or trust or powers of attorney. In this regard, the most basic elements of competence are, who your family is, what the assets are that you have, and where those assets are going to go when your death occurs. And so if in my office, we send out a questionnaire. That's the way that we help people gather the information that's necessary. It's going to ask, information about the person's family, a person's assets, and then getting them started to think about how they want stuff structured in their plan, who's going to do which jobs, what the distribution is going to look like. Because ultimately, those are the pieces that will need to be understood so that you can prepare the documents and all that. So I mean, I think that at the most basic level, those are the kinds of things that would need to be considered. Now, that sounds very simple on some level. However, there's nuance to this, right? I mean, so most of my clients, when they come in, will say, well, I know, I'm married, so I'm going to give everything to my spouse when I die. And then I have kids, and if my spouse is dead before me, then I'm going to give everything to my kids, and we'll split it equally between them, which is great. That's a good basic distribution pattern. The problem is that I will then ask them the question, so what if one of your children has died before you? And they look at me like, oh my gosh, we didn't think of that, right? And then the question becomes, do you want the assets to pass to your children outright, or do you want it to be held until their older ages? And we can set up special kinds of arrangements to hold those assets in a trust until they get to those designated ages. We can still allow the money to be utilized and those assets to be utilized for those kids, children. They don't have to be kids. They can be adult children, even prior to the full distribution. But this is not something that is just a simple process. Now, I'm here to say, I'm an attorney, so I obviously have a bias in this, so I'll put that out front. But the reality of it is, there are a lot of people who don't do any planning at all. I mean, the great majority, we could pull the folks on the call here, and I would, if it's, typical to general statistics, there's probably about 60% of the people that don't have estate plans, any written planning at all. And of those 40% that do, this is something that people try to do themselves. I have to tell you that when it goes wrong, it goes really wrong. So, I mean, it's possible to pull forms up online because, the internet's a great tool in ways, but it also has a risk. I mean, we don't cut our own hair. We don't change our own oil. We shouldn't be practicing law on ourselves. It's my way of thinking about it. This is a specialized inquiry. And, the problem comes if it's done wrong, you're not going to be around to fix it because you'll either be incapacitated or you'll be dead, and you can't get it right at that point. And it's just a matter of fighting it out. I know, because we see this in our practice on a frequent basis, the cost of fixing the problem is way more than the cost of doing it right up front. And that's true in so much in life, but it's true especially here.
Great points, Howard. And then, so you gather all this information, you think about, who your agents are going to be, or who the executors of the trust will be. You get these documents created for the estate plan. Where should you keep all of this stuff?
Yeah, so most people, I think, keep them at home in a safe place, either safe at home or a drawer that's secure. It is possible to keep documents like this in a safe deposit box at the bank, credit union, if they have a safe deposit area. With wills, you can actually store them at the county, at the probate court. I don't have many of my clients who end up doing that. It's because it's a little more complicated to get access to. If you need to change it or whatever. My general suggestion is to just let people know, your family and friends who are going to need access, to know where you're keeping them. And the reason for that is, if you grow incapacitated, you want to make sure that they can figure out where this stuff is. If you've buried it somewhere that no one can find, it's as good as not existing. So those are the typical places. I know that some law firms retain originals. It's been my practice through my course of practice not to keep originals for my clients. The other thing that's sort of connected with this, I suppose we should touch on, is the challenge of people wanting to change their documents. So if you have an existing plan, how do you make the changes? And one of the concerns that I raise regularly with my clients is to not write on these documents. Writing on the document could invalidate part of it or the whole thing, and that will be a real mess. So, if you're contemplating changes, do not just scratch something out and write something over it, because that I'm here to tell you, that's bound to be a contest issue. The other element to that, and I haven't seen this case come into my office yet, but I know it's out there and it's probably on its way to coming to fruition, is people who intend to make changes. They put sticky notes on their documents with the written notes of what they want to change, never actually change the documents, and then they grow incapacitated or die. I know that case is out there. It's going to be common because, and there'll be a fight over whether that sticky note was an amendment to the trust or, that's only a matter of time. The other thing that's really important to think about in terms of changing documents is once you've made those changes, it's important to make it clear which is the last original of these documents. Now, I think about, like Aretha Franklin's estate, right? We're more familiar with Aretha Franklin in our town. She had multiple wills or documents that could be wills, and there were several of them, and they're now working through which one counts. That's not an ideal situation. So having multiple documents when it's really important to keep the last one, that's an important thing. Now, there's some documents though where it's important. This is exactly the opposite. There's some documents where it's important to keep the whole set, right? So if you amend a trust, it'll be important to keep the original trust document, even if you've made changes by amending the trust. If you think about a trust as a full circle, and we amend it by cutting out a bit of that circle and replacing it with another bit, that means that we have to have something to reference back to the original document. Everything with a trust relates back to that original document usually, even if the document gets what's called amended and restated, which is basically an overlay of a whole new trust. The language is basically a whole new trust, but it relates back to that original trust. So there's in that situation, you don't want to have had the person throw out their older trust because you need to get all the way, you want to have a continuous line. But then there's some documents where it is important to get rid of the superseded documents. Think about old powers of attorney that are no longer in force, just so there's no confusion over which is the active document. It goes without saying that keeping these documents in an orderly way is sort of a critical task here, right? Just throwing them in a drawer and having a whole mess of papers is not going to be so helpful upon your incapacity or death. This is one of the kinds of things that you really want to keep orderly.
So should the documents be dated?
Oh yeah. I mean, any of these documents, when they're signed, the document should have, the signature, but also the date that it was signed. Some of these documents will need to be notarized. Some of them won't need to be notarized. They'll just need to be witnessed. Yep. But and they do need to be signed with the correct formality, right? So that there's the laws around this spell out what should be signed in which sort of way. We want to make sure that those formalities are carried out. And that includes, the signature, the dating, the witnessing, notarizing, that sort of stuff.
So you talk about changes. So we know that people will want to make changes and update these. How often should these documents be updated, or what occasion should you go in and change things? What does that look like, Howard?
Yeah. So the idea behind an estate plan is that it's reflective of a moment in time, right? So if we created an estate plan in January of 2022, and then that we can know right now, if we're setting up that plan, what we think we know going forward, let's say a year, 2, 3, 4 years, but we really don't have a good picture of what 5 years or 10 years is going to look like for us. I mean, realistically. And so my recommendation and that's true both in terms of our family circumstances, where we're living, what our assets are. So, I mean, it's the whole gamut of our personal existence, right? So the estate plan can do its best right away, but then over time, it might not be as valuable because things have changed. So when those things change, it would be important to update the document. Now, what I recommend is taking a look at the documents after they've been set up and pulling them out once a year. And that once a year review is really just to make sure that the agents who you've named are the ones you still want, that the distribution is still the intent that you have, those kinds of things. And then I would say every 3 to 5 years is probably worth sitting back down with the attorney to take a look and see what's changed in the law, because the law is always changing, as we know. And there's new opportunities, there's new pitfalls. In our, as I said, our personal situations change as well. So those need to be addressed in the documents, and those documents kept up. I have some cases where they haven't changed the documents in decades, and the documents are still perfectly fine. I mean, they're not fully up to date with all the latest nuance in the law, but they're sufficient for getting done what the person wants done. Having said that, there's new things that are happening in the law all the time that didn't exist. I mean, I was on a call this morning in Michigan. I helped pass the Fiduciary Access to Digital Assets Act, and that's to allow people to have access to your digital assets like your email, or your social media, or your online banking if you grow incapacitated at your death. That law was passed just over 5 years ago, and many people don't even know that that's part of what can be put into their plan, but it's really critical, because if you don't have a specific mention of it in your estate planning documents, then your agents, your trustees will be limited perhaps in what information they can access upon incapacity or death. So those kind of changes to contemplate changes in the law are really important, perhaps. And then, changes in family circumstances, births, deaths, movement over, if you're moving from different places. One of the questions I get asked often about that kind of thing is, if I move within Michigan, do I have to change my estate plan? And the answer is no, you don't necessarily. I mean, it might be useful to have it reflective of your current address and all that, so that when you go to the bank or have your agent go to the bank, they're like, well, this address doesn't line up with our information. But overall, the document should still be in effect and effective. The point where it would be necessary to modify things, though, is if you move out of state. So whether you move to Ohio or Florida or California, it doesn't matter, as long as it's not Michigan or even out of the country, right? Different states have different laws. And so the plan should be reviewed in light of the law in the new state to determine whether it would be appropriate to update the plan to reflect the new state's laws, or to keep Michigan law because it's more beneficial for some reason. Yep. And one other thing about that, we have a lot of our friends and family who are snowbirds, right? The people who live in Michigan part of the year, and then somewhere warm the other part of the year. The challenge in those cases is really figuring out where it is best to do the planning. And I tend towards having the plans drafted in a place where they're filing their taxes, where their driver's license is. Those are indications of a person's domicile, where they are and where they intend to return. And so that's usually the better approach. Now, if it becomes a close question, if there's some other advantage for doing a different sort of planning approach, then we would need to think about it on an individual basis. But generally speaking, that's a topic that's an important one.
Okay, good, very good. So you touched on power of attorney. So we hear a lot about power of attorneys these days, and needing to appoint agents under power of attorneys, and understanding that there are different types of power of attorneys. So could you explain the different types of power of attorneys, and what kind of like rights an agent has under each?
Sure. Yeah, so I had mentioned these earlier a little bit, but we can dive into them a little bit deeper here. So let's start with the financial power of attorney. So what this document does is it allows you to name an agent, and the title for this is called attorney in fact, is what the agent's name is. Now, the problem with lawyers is we weren't marketing people early on. And so all the stuff, all the different names of things, they're all sort of messed together. They're so it's a little confusing potentially. And so let's try and tease this apart. So the agent under the financial power of attorney is called the attorney in fact, but it does not need to be an attorney. So a lot of times it's a spouse, it's a child, it's a friend. That person is given authority under the document. It is a written document that spells out that the person has powers, and it can be narrow or it could be broad. So the broad kind of powers would be powers to deal with banking or pensions or taxes, contracts, lawsuits. It could be dealing with digital assets, like I mentioned before. It could be more extraordinary powers, like the powers to create or amend trusts, or the powers to make gifts. Those can be very useful tools in long-term care planning settings. When we need, if we need to help qualify for someone for Medicaid, for example, having the powers to create special kinds of trusts that would help a person qualify for Medicaid can be very useful. If those powers aren't in the power of attorney, then the agent doesn't have those powers. It can be powers to deal with real estate, so buying or selling or managing real estate. Powers of attorney for finances are effective either immediately or upon incapacity. I generally like to suggest that my clients make them effective immediately because I think they're more useful that way. And the person who's getting authority is usually a person who already has authority in most cases. Think about a spouse situation, right? In most people's powers of attorney, they're naming their spouse as their agent. Well, they're already joint on most of their stuff anyhow. So naming a spouse as an agent isn't much of a risk because they're already acting together anyhow. If the power is effective immediately, then the agent has effective authority right now. If the power is what's called a springing power, it's only effective upon incapacity of the principal, of the person who created the power of attorney. That can be less useful in ways. So if you think about how the springing action works, it springs into existence and usefulness if the person is determined to be incapacitated. And usually that's like by two doctors saying that the person is incapacitated, certifying that that incapacity has occurred. And if a person is traveling on business and there's some transaction that needs to occur, they're not incapacitated. They're just out of town. So that power isn't nearly as useful. So that's generally speaking, that's why I suggest having financial powers of attorney be effective immediately as opposed to a springing power. The second power of attorney that we talked about was the designation of patient advocate. So in Michigan, we don't have living wills. We have these patient advocate designations. And what that patient advocate is authorized to do is to make medical decisions for a person who grows incapacitated. Now, the patient advocate designation is in fact a springing power. So as long as the person who made the document out is able to direct their own medical care, they're in charge. It's only upon an incapacity determination that the patient advocate steps in. The powers granted in many patient advocate designations are for medical decisions. So it's physical health, mental health, dental health. It's the whole gamut. It can be broad or it could be more narrow if the person chose to, but most of the documents that I see are broadly drafted. It contemplates end of life decision making, which is something that living wills typically think about. So the patient advocate will be perhaps charged with making those critical decisions at end of life about whether the person should, stay on the ventilator or come off, whether CPR should be performed. Not to confuse the patient advocate designation with the do not resuscitate order. Right. So a DNR is a little bit different. It basically is a document that is put in place in consultation with the person's physician that says, don't resuscitate me. If I'm in a bad way medically, do not resuscitate me. But it's the patient advocate designations have both the ability and the power to direct that the care be continued to be provided. It can also give authority to end that care. So it's sort of both ends as opposed to the DNR, which is very specifically don't do that action. to keep a person alive. And as I mentioned before, the Hipaa release, it's not exactly a power of attorney, but it's sort of similar. One other power of attorney that's worth mentioning here, for those who have children who are minors, it is possible to prepare a power of attorney over your minor children. Let's say you're traveling somewhere and you're leaving your kids with their grandparents, for example, and you want the grandparents to be able to care for those children in circumstances that might arise while you're away. A specific power of attorney over those children is permissible under the law. Oh, and I should probably pick this up here too. I mean, it goes back to the will part of the discussion, but it's probably worth thinking about since we're talking about children, minor children. It is important under a will for those with minor children to nominate guardians and conservators for those minor children. If a person dies and the minor child's other parent is either not around or deceased, or not part of that child's life legally, then nominating who should serve as that child's guardian will be a very important piece of this. The guardians and conservators that I'm thinking about would act until the minor child reached age 18. And if they're older than 18, then those things won't apply necessarily.
Okay. Thanks. So we have lots of audience questions, but we do have one more question for us to get to, and then we're going to get into the audience questions. What happens if someone becomes incapacitated or dies without any estate plan?
Yeah, that's a big question, actually. So, and it's a reality for a lot of people, right? As I said earlier, most people don't have written plans. So let's think about a person who is alive but incapacitated with no written planning. So they don't have a power of attorney for finance or medical. They don't have a trust in place. It's just they're holding their assets. Now, it will depend on how those assets are titled, right? So if it's joint with someone else, then the joint owner presumably can manage and get access to those funds and assets. But let's think about a person who's grown incapacitated and has assets in their name only without joint ownership. In that situation, that individual is going to need a conservator to appointed through the probate court to manage their financial affairs. And then if they can't manage their living situation, then they would also need a guardian through the probate court as well. So let's break that down a little bit. A guardian is a court appointment to manage someone's welfare. Where are they living? What their medical needs are they being met, and how are they being met? If it's a minor, are they going to school? Making sure that their general welfare is managed. A conservator is also appointed through the probate court. The job of the conservator is to manage a person's financial affairs. So whether it's cash in the bank or investments or real estate, businesses, any of that sort of thing. So a conservator is managing a person who's grown incapacitated's financial affairs if they're alive still and can't manage them themselves. The other thing you should know about a conservator, interestingly, in Michigan, you don't have to be incapacitated to have one set in place. If you're an older adult, the statute actually allows you to identify that you want to have a conservator to help you manage your fund. Think about the SAFE program, right? I mean, so someone who is concerned that they are no longer able to manage their financial affairs, but they don't want to set up a power of attorney. I'm not sure why they wouldn't do that, but whatever, let's assume they don't. But they'd much rather have it go through the courts. They could request to have a conservator set up. Now, and the reason I say that most people won't want that, especially if they can avoid it, is that an ongoing administration through the courts is both, time and cost expensive. It takes more effort to do that, to an ongoing reporting requirement to the court on a regular basis. So it is something that most people, if you ask them, will want to avoid as opposed to have. So that's the answer to the question of, so what if someone dies, or excuse me, what if someone grows incapacitated without written planning? Let's think about the person who dies without written planning and what happens to their situation. So if a person dies without written planning, if they have assets that are jointly held or beneficiary designated, then those assets are going to pass the name beneficiary to the joint owner. There's not probate that's going to be involved in those typically. If you think about assets that are in that person's name only, without a joint owner, without a beneficiary, we've talked about this. This is what's going to go through probate and go through that probate administration. Now, there's a statute that would spell out in that case who gets what out of the estate, and there's an ordering. There's priorities about paying administrative expenses, reimbursing the funeral, paying other allowances, paying taxes, paying creditors, and then distributing under the statutory distribution scheme, which may reflect exactly what the person would have wanted anyhow. Right. I mean, the laws of intestate succession are what control when a person dies without a will and has assets in their name only. The spouse is given primacy in that intestate distribution. Children are given a secondary role, but the next highest up. It gets a little more complicated if you have a situation where the surviving spouse is not the parent to the surviving children, right? There's a division then between what the spouse gets and what the children get. But if there aren't surviving spouse or children, then are there grandchildren? If not, are there surviving parents? And I should say the law looks to who the heirs are to make the distributions, right? So it goes to parents, not parents, then siblings. If there aren't any siblings, are there nieces or nephews? If there aren't any of those people, are there grandparents, aunts, uncles, cousins? If none of those people exist, then it goes to the state of Michigan. So they'll take our last resort as the state of Michigan in an intestate case. The unfortunate outcome in some cases is that there are heirs that will receive a share of an estate where the person who died didn't even know who this person was. And we've done cases in Wayne County where we had, conference tables long genealogies, the moieties, and there are cousins that are just so far flung that they would have no idea that this person even existed in the world. And yet they were going to get something out of that estate. And I'm sure that the person who died, either didn't appreciate that was how the thing was going to go, or didn't care, whatever. I mean, but for those of us on this call, the concern I raise is that having no plan may or may not result in a good outcome for what you would intend to do with your estate.
So that takes care of the questions that we had to cover. We have lots of audience questions in about 15 more minutes. I'm going to try to get to as many.
Well, answer them fast. This is a speed round.
Yes. Am I understanding you to say, this is from Lori Sawyer, and she says, am I understanding you are saying the bank accounts, et cetera, should have the trust names rather than the individuals?
So this is a question about how to fund your trust. If you have a revocable trust, you need to decide which assets should go into the trust right away, eventually, or not at all. And so depending on what the intended goal is, it will be one of those three things. I have many clients who set up a revocable trust and they have their bank accounts, and we decide that we don't want to put them into the trust right away. We're going to keep them in their individual names for the time being and designate the trust as the beneficiary. So at their deaths, it'll flow into the trust. The reason that outcome makes sense often is many of us at this point have auto pays and auto withdrawals out of our banking. And if you set up an account naming the trust as the title owner on the account, they're going to make you set up a brand new account, which means you have to undo all that and redo all that structure. And most people don't want to do that, and justifiably, right? I mean, it's a pain to set it up, and it's a pain to set up a second time. So the outcome is accomplished. Similarly, though, if you set up, or keep the account in your individual name the trust as a beneficiary, use a financial power of attorney while the person's alive to be able to give someone else access, to the account if that's appropriate. But Lori's question raises a great point, which is that if you have a trust, it is critical to deal with the funding of it, to making sure that the assets that you have are properly set either into the trust right away, eventually, or not at all. Because what we don't want to have happen is assets that will be left out there in the person's name only, without a joint owner, without a beneficiary, and have to go through a probate process for those assets. Thanks for the question, Lori.
David Singstock asks, is it better to make the beneficiary of a retirement plan, a 403B or 401k, a real person or a trust with the same person as the beneficiary, I guess, as the executor of the trust?
Yeah, sure. So the question thinks about, again, a trust funding question, right? So IRAs, 401ks, 403Bs, all those deferred assets are much more complex questions to answer about funding. It is possible and in many cases desirable to name an individual as a beneficiary. If an individual, and the reason I say that is that there are some individuals that get to stretch out the timing of when assets have to be pulled out of an IRA. And I'll use that term generically to think about IRAs, 401s, 403s, all that together. Any tax deferred asset. And I'm not thinking about a Roth here. Let's just be clear about that. So I'm thinking about like an IRA where you put money in pre-tax, it grows tax deferred, and then when you pull the money out, the tax has to be paid. And then there's some requirements that either because you've hit your required minimum date that you have to start withdrawing it, or that your death occurs and then the beneficiaries will have to start withdrawing it. The question is how to stretch that out and benefit it the most. Sometimes, so I'll give sort of an unsatisfying answer, David, and I'm sorry about this, but feel free to call me and I'll put my information. Actually, I'll throw this up in the chat in a second. I'll put my contact information. You can feel free to reach out if you want to ask about it more closely. But what I would say is that the determination of whether it should be naming a beneficiary as an individual or as the trust is really going to depend on who the beneficiaries are and what the best outcome is and the most desired outcome is for stretching out the distribution to defer the taxes.
Okay. Renee Maxwell asks, what and should, I guess this is another trust funding question. What and should all assets be included in the trust?
Yeah, so, well, I think we've sort of hit on that a little bit, Renee. I mean, for every one of your assets, there needs to be that determination about whether it should be in immediately, eventually, or not at all. And what people want to do and need to do is make sure that that funding happens so that they do avoid probate at the person's death because the assets haven't been properly titled and it leaves it in one person's name only. What in that situation, just to follow up slightly, what happens is the probate will happen, but when the trust is set up, we prepare what's called a pour over will. And that will is a specialized kind of will that catches those assets that are in the deceased person's name only, going through the probate, and then dumps them over into the trust. And then the trust distributes out finally. So it's sort of like a connected document. It's a specialized kind of will, different than if you don't have a trust and have just a will focused plan.
Lisa Huffman asks, is there a minimum amount recommended to create a trust?
Yeah, thanks for the question, Lisa. So the short answer is probably not. I mean, there are cases that we work with that people have very limited assets, but they still want to set up a trust. There are some clients who come in and pound the desk and say, I want to avoid probate at all costs. And you look at the size and scope of their estate and you're like, it's not going to be that much different if you end up going through probate. Or maybe we'll set up an estate that has a bunch of beneficiary designations. And maybe it won't go through probate at all. It'll just go through beneficiary. And you don't need a trust, and you probably don't even need a will. We might be able to get away with getting a proper designation set up and it'll go exactly like your intent will be to carry it out. So technically there's no minimum. I mean, realistically, these things cost money to set up if you're working with an attorney. So, there's that threshold that needs to make sense, right? I mean, the cost of preparing it and setting it up needs to be justified by the protection of the assets that it's contemplating.
Miss Maxine Brown asks, if you have designated beneficiaries, do you still need a will?
So Maxine, I answered your question already, which is You might not need a will. I always say though that it's useful to have, even if everything is going to go through beneficiary designation. Here's why. Let's say that you miss something. Now, if you miss something and the distribution intent is what would be carried out through the intestate distribution, then maybe you don't need it. I mean, one of the benefits of having a will also is that you can designate who the personal representative is who's going to administer the estate, right? So that's a prerogative that you would have if you had a will, but if you don't have a will, then it's left open to whoever shows up. There is a statutory scheme that describes who has priority, but there's that open question. And then in terms of what ends up happening with your assets, if they aren't controlled through a will, then you'll just get the intestate distribution, assuming that they're in your name only without a joint owner or beneficiary. One other problem with beneficiary designations potentially is if you fail to name enough layers of beneficiaries. So think about the situation where I'm married, I name my spouse as my primary beneficiary, and I never name a contingent beneficiary. And then my spouse has died before me, and then my death occurs, and then effectively there is no beneficiary, and then that asset will go through probate to be distributed. So having a one layer of beneficiary is usually insufficient. The other challenge with beneficiary designations is that they're sometimes limited in what you can do. Think about my child scenario where I said, so what if so I name my spouse first and then the kids are equal share contingent beneficiaries, but one of my children has died before. The question of the nuance of what you can do with that deceased child's share, if it goes to the other children, if it goes to their kids, so your grandkids, depending on how the beneficiary is structured, that may or may not be able to be contemplated, first off. And secondly, let's say that it isn't spelled out specifically. There's going to be default rules in all likelihood with the financial institutions you're working with that will say what happens in that default situation. That may or may not reflect what you want, right? It might say you give it equally to the other surviving kids, or that wasn't what your plan was. You really wanted it to go to the grandkids, right? So there's complexity in this, and it needs to be thought through and carried out. I can tell you that I have a lot of situations, or a lot of cases that come into my office where I ask about beneficiary designations, and the response I get is, well, we think it's whatever they say. And my point to them is this shouldn't be a guess. There's too much riding on guessing. You want to make sure you know what your beneficiary structure is, and to the extent that it's not reflective of what you currently are intending, then you need to change it.
Okay, so Miss Rosemary Aldridge, my mom just passed away and she made me the power of attorney and the personal representative of her will. My question is, do I need an attorney present when I read the will? The will was witnessed and signed, or do I need to go to the court to execute the will? Our condolences, Ms. Rosemary.
Yeah, I'm so sorry to hear of your loss. Your question has a lot in it. Let's try and break a few of these pieces out. So I'll break a myth apart first. In most cases, there is no reading of the will. That's Hollywood. So you don't need an attorney to read the will. You really don't even, you don't even need to have a family gathering. It might be that it's just that the information is shared out with those who are interested in the estate. So the question about whether you need to have an attorney involved is really going to depend on the complexity of the estate, the complexity of the relationship of the parties, your willingness to learn a system that you know nothing about perhaps right now, right? There's a steep learning curve in this process. I can tell you that there are a lot of people that end up doing this without an attorney. And so I won't sit here and tell you you have to have an attorney. That's not true. You don't need to have an attorney necessarily. The benefits of having an attorney involved in your situation, in your case in this instance, is that that person will be able to provide good guidance to you on what you should and what you shouldn't be doing, and how to do it right so that it's less likely to be fought over and it's more efficient. Those are the benefits, I think, of having an attorney. I'm sorry, were there other elements of that question? There was a lot there.
I think that was it, and asking, does the probate court need to be involved? When she, but you
Well,
said,
in the question about the probate court involvement will really depend on what the assets are and how they're titled.
okay. Patricia Smiley asks, at what age or mental condition is it too late to make a trust?
So thanks for the question, Patricia. Yeah, there's no set age after which a person is too old to make an estate plan out. So it really is a question of capacity. So if a person is able to match those basic, understandings, who their family is, what their assets are, what the distribution plan is that they intend, if they can articulate that, then that person can still make a trust or a will, even at an advanced age.
Capacity, yeah. And I think you already answered this. Regina Poole, if a trust has been established and you want to amend it, can the trust be revised by a law firm?
Yeah, so Regina, what the best answer I can give without seeing the documents would be, it depends on the kind of trust. It depends on when you're talking about amending it. So a revocable trust, the main feature of that is that it typically can be amended during the person's lifetime if they're alive and with capacity. There are some situations, even in a revocable trust, where you can't do that though, because the thing about a spousal situation where the first spouse has died, it might lock in the trust terms at the death of the first spouse. And if the person has already died, those trusts are not easily changed at that point. Now, I won't say that trust terms can't be changed even after a person is deceased. It is possible to get through court involvement or through the agreement of the parties a different outcome, but it is less simple to do for sure. And the question, should it be revised with a law firm? I think it goes back to the conversation that we had earlier about, the desirability of getting it done right and not having unexpected outcomes if you drafted them properly.
And then Ms. Shelley Clifton, if you remarry after establishing a trust or will, does the new spouse have any access? Oh, excuse me. Does a new spouse have any access rights if not named in the will or trust? What's the best way to ensure that your children continue to inherit everything as listed in this statement?
All right, so remarriage poses its own set of interesting issues here. The answer, I'll give the lawyer answer, which is it will depend on a lot of things. Was there a pre or post nuptial agreement in the remarriage or in the second marriage? If there was, then the terms of that pre or post nuptial agreement may determine the new spouse is entitled to something or nothing, or when they might be entitled to something or nothing. Without looking at the documents, it's sort of hard to answer. There are the new spouse may have an interest in the estate, though, especially if assets are commingled. So if you get remarried and you set up a joint account with the new spouse, and then your death occurs, that's a joint account, and that new spouse is likely to receive those assets. So it will be important as you proceed in a remarriage setting to contemplate the goal of whether it's going to keep things joint with the new spouse or to keep them separated. And that's in whole or in part. I mean, and you can certainly pick and choose. It doesn't have to be one or the other necessarily. Protecting children from the prior marriage, it would be very important to have a well-crafted estate plan in that case. There are types of trust setups where we can make sure that there is a carve out for those children from the first marriage to preserve their share.
We are right at the 2:00 hour, and I know, Howard, you're very busy. With the rest of the questions, can we put your email possibly or in the chat?
I put that in the chat.
Okay. So Attorney Collins and my contact information is in the chat for anyone who would like it to actually send any questions that we did not answer. We apologize that we ran out of time for questions. But once again, thank you all so much for joining us today on this very important session. Oh, I'm sorry, I'm trying to put my email in the chat. I'm sorry. This
No, it's
very
okay.
important
Let me talk
session.
for a second to say thank you too for all the great questions. And I see there's a lot of good questions in the chat that we didn't get to, and I apologize for it. I wish we had more time, but yeah, certainly reach out to me. Feel free to call me. I'll even put my email in the chat here. So if you want to send me an email.
And for everyone, while Howard is doing that, again, my name is Latoya Hall. I'm the director of the SAFE program at Wayne State University. We assist older adults with financial issues that have occurred as a result of being financially exploited or general financial management issues. If you need to reach out for services, or if you have a client who could benefit from our services, please feel free to contact me at the phone number and the email in the chat. Thank you so much, everyone, for stopping by and seeing us today. And don't hesitate to contact me or Howard with any further questions. Bye, everyone.
Bye. Thanks again.